Good morning, everyone, and thank you for attending today's webinar. My name is John McLeish, and I am going to be chairing the program today. This program is being put on by the Personal Injury Alliance. There's been a lot of changes since June 1st, 2016, and this program is titled A Year in Review, Understanding the Impact of the SABS Changes, and the purpose of the program is to help us all make it a little easier to do our jobs and make us more effective. Just before I get into the details of the program, I would like to tell you about the next conference put on by the Personal Injury Alliance, and that is the Back to School Conference that is being held on Thursday, September 28th, and again at the Carlu. The format today is going to be that the panelists talk for approximately 10 minutes, and you can ask any questions that you have. You'll see at the bottom of your screen a place to ask questions. We will do our best to answer them during the program, but if we can't, we will then send out an email after the program with the answers. If you can't stay for the whole program, or you know someone that wants to see the program and can't make it today, the program is being recorded, and it should be up on the PIA website in approximately 24 days or so. So it'll be up there for the duration for those who can't have not been able to attend today to attend. So I would now like to introduce our panelists, and I'm going to start with Brenda Power to my right. Brenda is an occupational therapist with a company called Solutions for Living. She is a co-owner of that company with Julie Entwistle, and she is also a CAT assessor. Brenda is going to discuss understanding the CAT definitions and how she can help all of us have our clients better meet the definition and generally work with the new system in place since June 1st. Another panelist to my far left is Benson Cowan. Benson is the head of legal services for the Safety, Licensing Appeals, and Standards Tribunals. You ask what that is. That is the overseer for 5 adjudicative tribunals, one of which is the Licensing Appeals Tribunal, which we all affectionately know as the LAT. And Benson is going to give us an overview of the LAT process, again, with a view to helping all of us work better and more effectively within the new system. And of course, the LAT is the new dispute resolution system. A third panelist to my left is Brian Cameron. Brian is a partner at Oatley Vigmond, one of the other law firms with the Personal Injury Alliance. Brian is going to discuss with us how to prepare ourselves to go through the LAT process from application to case conference to hearing. And the fourth and final panelist to my far right is Steve Birman. Steve is a partner with Thomson Rogers, the other firm with the Personal Injury Alliance. And Steve is going to discuss with us, there's been a number of cases coming out of the LAT in the last year. Steve is going to discuss with us some of the more important decisions that the LAT has come out with. So without further ado, we will get started with Brenda.
Thanks, John. Good morning, everyone, and thanks for joining us. You'll note in my PowerPoint presentation, I have listed for you in the first couple of slides some of the major changes that were introduced in the statutory accident benefits changes that occurred on June 1st, 2016. In the interest of time, I will not go through all of them in detail. However, if you skip to number 4, I will go through the major changes to the catastrophic impairment definition, as I think they are important in light of the topic of today's webinar. The first change is with respect to the Glasgow Coma Scale. In the old legislation, our clients were able to get an automatic designation of catastrophic if they scored 9 or less out of a total of 15 using the Glasgow Coma Scale. Under the new legislation, this is not possible. The second major change is with respect to the mental behavioral impairment. So what I'm referring to here is catastrophic assessment using the 4th edition of the AMA guides, the American Medical Association guides, 4th edition. In the old legislation, we required 1 marked or class 4 impairment or 1 extreme or class 5 impairment in order to receive a catastrophic designation. Under the new legislation, we now require 3 marked impairments or 1 extreme impairment in order to qualify as catastrophic. So this is another significant change. Thirdly, with respect to adult brain injury impairment, the criteria under this change requires that there has to be positive findings on either a CAT scan, an MRI, or what the SABS terms as other recognized brain diagnostic technology. It's still up in the air a little bit in terms of exactly what this means, but if the positive findings on one of these tests is combined with the results on the GOSI, or the Glasgow Outcome Scale Extended, meaning a vegetative state at the 1-month mark, lower or upper severely disabled at the 6-month mark, or lower moderately disabled at the 1-year mark, then our clients can qualify as catastrophic. And finally, with respect to the change in catastrophic definition is with respect to pediatric brain injury. It's good that this area has been added to the SABS for our minor clients. And these criteria include that the youth has to be accepted for admission as an inpatient to a public hospital named in the superintendent's guide and have the positive findings on the CAT scan, the MRI, or the other recognized brain diagnostic technology that I just discussed. Or they have to be accepted for admission to a pediatric neurorehabilitation facility, or they can be vegetative at the 1-month mark using the King's Outcome Scale for childhood head injury, and this is sometimes referred to as the COSHI or the COSHI, or they can be at the 6-month mark severely disabled using this same tool. Or an additional criteria this SABS has indicated is that at the 9-month mark, if the minor is not age appropriately independent and requires in-person supervision or assistance for physical, cognitive, or behavioral impairments the majority of their waking day, then they can qualify for catastrophic under the new legislation. So I want to talk a little bit about an article that was actually written in 1998, but is recognized by the new SABS as being a very important one with respect to catastrophic assessment. And it's an article that was written by Wilson, Pettigrew, and Teasdale called Structured Interviews for the Glasgow Outcome Scale and the Extended Glasgow Outcome Scale Guidelines for their use. So the SABS does refer assessors to this article and the guidelines that the authors do put forth. The authors did recognize a couple of flaws with respect to the tools, and the guidelines were introduced as assessors for us to keep in mind when we're doing the assessments. And I'll go through those briefly. Number 1, disability due to head injury is defined by a change in pre-injury status. So where were your clients in terms of functioning prior to the collision or the accident, and where are they functioning now? Number 2, only pre-injury status and current status should be considered. So this is referring to the importance of not being swayed in our opinions by an amazing recovery that the client potentially might have had from the date of loss to the time when the assessment is being completed, or hopes or aspirations for your client's recovery for the future. It reminds us that we need to complete the assessment considering the client's status prior to the accident compared to where they're functioning now. Thirdly, disability must be a result of mental, meaning cognitive or emotional, or physical impairments, or both, resulting from a traumatic brain injury. So it's important to note here, there has to be a diagnosis of traumatic brain injury in order for assessments to be completed for catastrophic using the GOSI. And finally, the fourth guideline that they put forth is for us to use the best source of information available. So this speaks to the importance of completing collateral interviews if your client will, for example, provide consent to you to speak to their loved ones, their employers, anybody who can paint for us a fuller picture in terms of where the clients were functioning prior to the accident compared to now. And on your screen here, I apologize for the small print, but I know that you do have the PDF available, so feel free to print this off and to use it. It is a quick reference guide that I developed myself for quick use, as opposed to having to pull out all of the information when we have a client that we're working with and we think that potentially they might qualify as catastrophic. You'll note on the left-hand side of the screen, the scores of the Glasgow Outcome Scale are listed, followed by the next column, which is the outcome category. The next column is a little clock. So this column indicates the timelines and the SABS criteria. And in the final column on the right, there is the level of functional impairment. And again, because of timelines this morning, I will not go through it in detail, but if anybody has any questions about it or wants to discuss it, feel free to give me a call and we can set up a time to chat. But for example, if you scroll down to score number 5, if you're working with a client at the 1 year mark, for example, and your client is unable to work, if they are working potentially only in a sheltered workshop or in a non-competitive type of job, or they are rarely, if ever, taking part in previously enjoyed social and leisure activities, or if there is a constant disruption, meaning a daily and intolerable disruption to their family relationships and their friendships, at the 1 year mark, this would be determined to be a lower moderate disability using the GOSI, and using this tool, your client will qualify for catastrophic at this point. So moving right along then to the catastrophic assessment using the 4th edition of the AMA Guides, Chapter 14, and the 4 spheres of functioning. These 4 spheres are activities of daily living, social functioning, concentration, persistence, and pace, and adaptation. The first one, activities of daily living, is fairly self-explanatory, but what we're looking for here when we're assessing are changes to the client's ability to engage in their self-care activities, their personal hygiene, communication, ambulation, travel. Have there been changes to their sexual functioning? How has their sleep been affected? And are they engaging in social and recreational activities? The second sphere, social functioning, is also fairly well understood. It's defined by the AMA Guides as the capacity to interact appropriately and communicate effectively with other individuals. So this is whether or not your clients are presenting to you as what you would consider to be socially mature. The third sphere, concentration, persistence, and pace, defined again by the AMA Guides as the ability to sustain focused attention long enough to permit timely completion of an activity, or of a task, sorry. The key phrase here is the timely completion of an activity. How long did it take your clients to complete activities prior to their accident or their collision? How long is it taking them to do activities now? Are they in fact able to complete their functional tasks without being distracted by something in their environment, or by their pain, or by their anxiety, and so forth? And the fourth sphere is adaptation, deterioration or decompensation in work or work-like settings, or repeated failure to adapt to stressful circumstances. So how do our clients how are they affected by the introduction of stress into the performance of their activities of daily living? A couple of key things I wanted to point out here. A psychological diagnosis is an absolute requirement when assessing under Chapter 14 of the AMA Guides for Catastrophic. As I mentioned, we now need 3 Class 4 impairments or 1 Class 5 impairment to be deemed catastrophic. Collateral information, again, is very important here. Talk to people that the clients will provide us consent to speak to. And these assessments are done typically at the 2-year mark, or when a physician has deemed that our clients are medically stable. And to clue up my portion of this morning's webinar to start, I wanted to summarize for you the key points for rehab providers in my opinion. The first one is know the Glasgow Outcome Scale Extended, know the 4th edition, Chapter 14 of the AMA guides, and talk the talk in your assessment reports in the very beginning of the file, in your treatment reports as your treatment with your clients go along. Know these areas so that when the time comes to assess for catastrophic, your file is being prepared in that manner. Also know the Glasgow Outcome Scale and its scoring. If you do have accidents prior to June 1st, 2016, potentially they may qualify for catastrophic using the Glasgow Outcome Scale itself. Next, speak to the quality and the frequency of changes to your client's ability to engage in their previously enjoyed activities of daily living compared to the quality and the frequency of those activities now. If you look at the Glasgow Outcome Scale Extended, for example, a client can actually qualify for catastrophic based in a change in the quality and a change in the frequency of their ability to engage in those tasks. Prior to the legislation changes in the old days, I think we've always mentioned clients enjoyed walking their dog or going to bingo or playing basketball, for example, prior to the accident. Currently, my recommendation to you is talk about the number of times that they did that. They played basketball daily for an hour prior to the accident. Currently, they're playing once a month, for example, if they're still doing that. Know the Wilson, Pettigrew, and Teasdale article. Know the Glasgow Outcome Scale Extended and the results, and know the guidelines that the article does put forth to us to follow as rehab providers when assessing in this realm. Use activities of daily living or ADL checklists, for example, and this will also help paint a better picture of the client's functioning prior to the accident compared to now. Do situational assessments. These are very important. Real life examples speak to people. So take your clients, assess them in their homes if you're able, assess them in the community, and put that information in your reports. Collateral interviews, again, I'll stress the importance of talking to people that knew the clients prior to the accidents, employers, loved ones, in order to, again, paint that full picture and to get an idea of how the client was functioning prior to the accident. Communicate with your referral sources. If you know the language and the terminology that we're using here this morning, don't wait for the 6-month mark to highlight to your lawyers or your insurance companies if you think they may qualify for catastrophic. Start having these conversations at the 4-month mark, the 5-month mark, so that when the 6-month mark comes or the 1-year mark comes, you're ready to complete the catastrophic assessment. And finally, highlight both the positive changes in function, but also highlight ongoing areas of dysfunction in your reports. I think as rehab providers, it's really important for us to indicate how our clients are reaching their goals in terms of their function and how they're functioning well as a result of our treatment. But please also include and highlights the areas of dysfunction that they are continuing to have, because as the 6-month mark or the 1-year mark approaches, this information will be very important to paint that history. Thank you.
Thank you very much, Brenda. That was a wonderful talk. And a takeaway from that talk is this, in my view. You have to know the definitions, the new definitions of catastrophic impairment for this reason, and this is why the talk is so beneficial. Knowing what the criteria are for the new definitions, you can write your reports from the get-go, keeping in mind the definitions, so you can write your reports into the definition of the criteria if they're there. The other thing that I thought was so important in what Brenda said was collateral sources. If you not only get information from the injured person, but from family members and other sources, you will have a larger database than someone who does an insurer examination. And if the case does go through the dispute resolution process, you may have an advantage because your database of information will be larger. So thank you for that, Brenda. That was a wonderful talk. So Benson Cowan is going to be the next presenter, and his talk again, overview of the LAT process. Benson?
Thanks, John, and thanks for the invitation to participate in the webinar today. I'm going to give a bit of an overview and a bit of a context for the ABS coming to LAT, and I'll speak a bit about the larger regulatory and statutory framework under which we operate, and then I'll speak about the specific processes in LAT that are different from the fiscal system that came before. And these are, I'll focus on areas where we've received some feedback about where the process has changed, and it created, in some cases, some challenges for the parties. Before I get into that, I'd say that one of the ways that I look at what's happened in the past sort of year or so is that, you know, there's a body of changes or issues with the new process that were decided by the regulator and the ministry, and they made the decision to move the jurisdiction to hear these disputes to the LAT, and the LAT had nothing to do with that conversation. We are an independent tribunal. We're independent from the Ministry of Finance. We're independent from the Ministry of the Attorney General, and we don't participate in the policy or legislative conversations. And that's a significant feature that is somewhat different from the previous system, whereas previously the Fisco Tribunal was part of Fisco and had a more direct connection to the policy framework that we don't. We consider ourselves to be an independent service provider, and the service we provide is the litigation of, in this case, these disputes. So some of those decisions we don't have any control over, and we sympathize with the changes that have taken place. And but sometimes those concerns are best directed to Fisco or the Ministry of Finance. So that's the realm of things we don't really control. And then there's the realm of things over which we have much more control, our own processes and our procedures. And I look at those and I divide them into two areas. One is where we've made some really clear decisions about what we're trying to do, and where the system is working the way we want it to work. And again, that's created sometimes there's some change issues or there's some frustrations on the part of the parties. But and I'm more than happy to engage in a conversation as to why we made these choices and what the rationale is. And then, frankly, there's still a body of there's a body of issues where we have a clear idea of what we want to do, but we're not there yet in terms of what we're trying to deliver in terms of service. And there have been some problems in the early days with just trying to ensure that every case is being processed in the same way and with some consistency. And we're really alive to that, and we really appreciate any feedback we get in respect of it. One of the things to keep in mind about the new system is that there is a need to be prepared, and there's a need for speed in the new system. Unlike the previous system, we don't have a long mediation before arbitration. One of the features of the new system is once the application has come in and the initial responses have been made, we look to set a case conference as early as possible. That case conference is sort of the central controlling process of the LAT. In the case conference, we look to assist the parties to resolve cases. We don't provide a formal mediation, but we will assist in trying to drive a resolution. If a resolution isn't imminent, then that case conference looks to narrow the scope of issues to be litigated. We try and really focus on what's central to each case. And then we'll proceed to set a hearing as quickly as possible. And we're trying to get hearings set within 3 or 4 months of the case conference. Our expectation is that the parties, when they come to LAT, should be ready to proceed. And that, again, that's that's a critical difference from the previous system, where there was more time in the mediation phase under FSCO to manage to get your case prepared or to negotiate a possible settlement. And our system doesn't allow for the same leisurely pace once the application has been provided, has been submitted. There's a couple of other features of our system that I'll speak to quickly. One is the issue of adjournments. Generally speaking, the License Appeal Tribunal doesn't make it easy to adjourn a hearing. Once a hearing date is set, we lock in the resources that we have, and we expect the parties, once a hearing date is set, to proceed to that hearing. There are adjournments that will be granted. There's always reasons that come up, but we'll need evidence we'll need evidence and submissions about why the adjournment is required. And one of the features of the system is that the consent of all parties alone isn't going to be a basis for an adjournment. The rationale behind this has to do fundamentally with our concern about ensuring that the system stays free of backlog and delay. These are problems that plague the litigation framework across Ontario, and we're really concerned that as the LAT develops and hears these cases, that we don't contribute to backlog and delay of cases by allowing for adjournments cases to be adjourned repeatedly or adjourned too far out, and adjourned simply to accommodate minor changes of schedule or minor tactical considerations. And this has been very frustrating for a lot of the parties. But again, you can get an adjournment LAT. You just have to make a very clear argument that one is required. There's a couple, with respect to the issue of case conferences, they're much easier to get adjournments on case conferences. We recognize that we set those somewhat arbitrarily, and the parties it's easier for them to manage to adjourn case conferences. It's another key difference that we've received a lot of feedback on, and that is the cost regime. Under the old system, there was a rule that allowed for costs to be awarded, and they covered a broader array of circumstances. Essentially, they followed the victor, and our regime has a much more restricted power to award costs in the SPPA, the Statutory Powers and Procedures Act. The costs that the tribunal can award are limited to behavior that's frivolous, vexatious, and in bad faith. And across administrative tribunals in Ontario, that tends to be it's a very high threshold to get to, and the cost awards that result aren't the same as a cost award that's designed to that was present in FSCO, that was designed to compensate the parties for some of the expenses that they incurred. Another critical feature of the new system is the reconsideration power, and I would encourage all parties to look at the Rule 19 and the LAT rules. We're not going to get everything right. Mistakes get made, decisions get made that need to be reviewed, and we've got a reconsideration power that allows for the executive chair to look at decisions and to make changes if there's been a significant error made. Right now, there's no cost to the reconsideration power. That may change as we develop, but in the short term, we wanted to ensure that the parties had a quick route to appeal so we can correct any error without having to go to a court. There is, of course, a right of appeal. It's found in the LAT Act. There's an appeal on a question of law alone. We currently have about, I think it's about 10 or 12 appeals that have been filed. That may be a little high. Some have been withdrawn. And as a general course, the LAT doesn't appear on appeals. We will occasionally seek leave to appear as a friend of the court if there's submissions that we could make that would be helpful around the standard of review or any process or procedural questions that are specific to LAT. Given this is a new, it's a new jurisdiction for us, we're going to, we expect we'll be present in some of the early appeals just to make submissions on standard review and other issues as they arise. So, John, again, I'm happy to take any questions on any of those issues I raised. I know that many of them have vexed some members of the bar and some parties.
Oh, thanks for that, Benson. We'll take the questions after everyone gives their initial comments. One thing I took away from Benson's talk was, unlike pre-June 1 in the dispute resolution process, you can no longer proceed, to use his words, at a leisurely pace. You have to be ready to go. And that is so true, and that is a wonderful segue into Brian's talk, is how to prepare yourself to go through the LAT process. Brian?
Thanks, John. This is new. We're all learning about this, and since April of 2016, we've had to change the way we do things. I am happy to say that I did my entire career without ever once doing a fiscal hearing, because I'm very much a believer in courts, judges, and juries. But unfortunately, that right has been taken away from people in Ontario for the sake of speed. I mean, there is a saying, justice delayed is justice denied, but the converse of that, rushing people into things and forcing people into systems that are inherently unfair, is probably not a good way to do it for the sake of speed and the sake of saving money. But the law is what it is. We have to deal with it, and we have to do it. So I want to talk a little bit about what we've learned so far in seeing some of the LAT decisions and the process I've been through, and then talk a little bit about perhaps how to prepare, because it's going to be a little different than those of us who just prepared to go to court have come to deal with. When I was speaking about the LAT prior to the changes, when Justice Cunningham was first proposing the system, for the life of me, I couldn't understand why we would take the tribunal from people who knew the system and had worked in it in 20 years. Perhaps you want to change the system and give it to another body that has a lot of experience adjudicating things, but no experience in interpreting insurance legislation specifically, and very little experience in running these sorts of cases. The LAT probably is quite excellent in dealing with landlord-tenant, police service boards, all sorts of things. But they're probably not the people or the initial people that we want to have deal with what is essentially a private insurance dispute, contract dispute, between a very large insurer and a very ignorant plaintiff. But again, we're stuck with it. Now, I will say this. I had my first case conference, and I wish I could remember the name of the, I'm not sure what to call them, adjudicators now. I couldn't find anything that we're supposed to call them in the legislation, but did a wonderful job. Showed up, was prepared, knew the material. We got through it quickly. I'm going to talk a little bit about it in a minute. So it really is going to come down to the people that the LAT choose to hire to run the case conference, to run the hearing. We don't know who they're going to be yet, or at least all of them, and they're hiring more, I presume. But it's going to come down to the people. And we, as advocates for plaintiffs, can certainly help these people do their job, because although, as I've made pretty clear, I have my complaints about the system, I have to work within it if I want to help my clients get through it. And that's really, really what I want to do. We have to date about, my numbers maybe 3 weeks to a month out of date, I'm not sure, but about 5,800 applications so far. 3,500 were withdrawn. Seems like a high withdrawal rate, but the reason is unknown. It might have more to do with keeping things on track with respect to a tort case, and you want to withdraw it and do it at a later date, or perhaps a withdrawal is a means of getting an adjournment that you can't otherwise get if it's on consent. It's very hard to say. There have been, of those 5,800 applications, about 2,500 case conferences and apparently 149 hearings. So we're getting a very dramatic drop-off of applications to what is actually being heard. And the reasons, I think, we may be able to analyze in perhaps another year of decisions to figure out what's going on there. Are people just giving up because they can't recover costs, or are they just adjourning them for, or withdrawing them for other related reasons? We really don't know. And of those, and one of the features of the LAT that I think is going to be a little difficult, and I'll talk about this in a minute, is about 70% of the hearings thus far have been in writing. Now the remainder have been over the phone or in person, and we've got about 100 plus decisions so far. I think the number might be 103 as of a couple of days ago. And as my friend was noting, I mean, the rights of appeal are relatively limited, but not a lot different despite the language than appealing a decision from a trial court. It's, you go to the Court of Appeal, it's only supposed to be on a question of law, but I think what's going to happen is they're going to get into the palpable and overriding error in terms of facts, and that's likely to occur at some point in the future. Now, in reviewing most of the decisions, this is what it looks like so far. Insurers seem, overall, these are general comments, they're winning on the minor injury guideline, they're winning on income replacement benefits, and they're winning on non-earner benefits. Oddly though, insureds, your clients, are winning on treatment plans. Hard to know why that is. I think it might be because of the nature of most of the hearings are in writing. I don't think most plaintiffs' lawyers are used to doing this form of advocacy in writing without an oral component. The evidence for an income replacement benefit, for example, is so much more complex than the evidence for a treatment plan for a specific set of treatment, because you likely have the treatment plan, you have a report from the OT, for example, that sets out why it's required. It's much easier to explain to an adjudicator in writing why that particular plan is required. Now, an income replacement benefit is a lot more complicated, especially if it's a job that people don't see a lot or don't quite understand. There's issues with respect to accounting. There's a lot of advocacy going on. And non-earner benefit, the same problem. There's a lot of advocacy going on in proving that somebody has suffered a complete inability to carry on a normal life. It's not as simple as saying they need occupational therapy for 12 weeks and this is why. This is painting a picture of somebody's entire life. So when you're preparing for this is really what you have to start thinking of. And the first thing, as with anything else, when you're in court or doing anything else, you have to know the rules. You have to know the rules of practice. And there are a few of them we can use to our advantage. The most important one is this, is the timelines. I think the comment earlier was work at a leisurely pace. Well, you can make other people work at a pace that is not leisurely, because as the plaintiff, you control the timeline, subject to the limitation periods, of course. If I'm going to bring a LAT application for attendant care benefits, I'm certainly not going to do it before I have everything I need. And by that I mean I'm going to have a current occupational therapy report, a Form 1. I'm going to have whatever sporting medical documentation I need that's current. If that means reassessments in a brain injury case, reassessments if it's an orthopedic kind of case, whatever it is, make sure you have those records before you file the application. Because what triggers the passage of time and the limitation is the filing of the application. We completely control that. And the responses are very short. We're booking case conferences very quickly, hearings, as my friend said, 3 to 4 months after that. So if you start today, you have everything you need to argue your case today, file your application, the insurer has 10 days to respond to the case conference hearing. How are they possibly going to respond to all that correctly? They're either going to need an adjournment or they're going to be forced into it. And if we're going to be forced into something and it gets done quickly for the benefit of speed, we may as well use that to our advantage. And I should be clear here, I don't think it's fair for either side, but this is the rule. These are the rules, this is what we have to live with, this is what we have to work with. Get everything you need before, serve it with the case conference, and you're off to the races at that point. Now, the case conference itself is a little bit different than or the case conference material. You don't want to swamp the adjudicator with a bunch of meaningless material. They're going to have a lot of these applications, and they have to read them to be prepared. As I indicated before, the adjudicator I had for my case conference was fantastic. I believe mostly because she had time to prepare. Neither myself or the defense lawyer in the case filed a lot of extra information. The issues were discrete. They were just right in front of her, nicely outlined, very clear, very easy to understand, with a very simple summary of it. This is the issue. These are the records that we're going to support. This is in a paragraph of what they say, and there was nothing more to it. Now, that made it go smoothly. We were able to narrow the issues. We got a report back, and we knew exactly what was going on. Now, getting ready for the hearing itself, the one thing I would say is this. I am going to ask, unless my client presents so poorly that it will ultimately do a lot of damage to my case, I'm going to ask that every hearing I ever have to do is going to be oral. Now, I'm not going to get them all. I did on the first one. I was fortunate. I don't want to do it in writing because you're painting a picture of someone's life. I think it's much easier to paint a picture of someone's life by having that person tell the adjudicator, this is my life and these are my problems and this is what happened to me and this is what I need. Or having a doctor come in and say. And doing things in writing also, we lose the opportunity to confront the people who present evidence against us in an effective way. Reports say what they will, and there are a lot of times on both sides, and the comment applies equally to plaintiff and defense, that things look a lot better on paper, but they don't hold up to much scrutiny when somebody has to say them out loud. I sometimes wonder, some defense reports I see, I look at and I go, geez, I wonder if this doctor can actually say that without giggling. Because that's, you know, kind of a good test, and sometimes they can't, and sometimes they can. But I like to be able to test that. I like to be able to do the hearing orally, because the things, you're also able to react in the moment to something that happens. You can't do that in writing. But if you're stuck to doing it in writing, this is not a summary of evidence. It's not a summary of a medical document that supports a position that you say. It's not enough to say for income replacement benefits that your person, here's the orthopedic report, your person was a mechanic, he's got a bad back, and the doctor says he can't work. Well, that's not enough, because you need to provide some context for that person. You have to treat it like a mediation or a pretrial. Written advocacy is very important, because what the adjudicator is going to have are a lot of reports, but probably the first thing they're going to read to get an idea of the case is your summary and the defense summary. You need to paint a picture of who your person is, and that is going to include will say statements, witness statements. What do the friends and family say first about what this person was like before? What are they like now? There's going to be photographs. I would never want to put a brief, I want the adjudicator to know it's a person. There's a real person here. This is what they look like, and here's this person with their kids when they're happy before they get hit. And then you're going to talk after and explain what the job is. Get the employer to give you a statement about how, yeah, your client came back to work, didn't do so well, had to leave. Then weave in the medical evidence and use the treatment evidence. Very important, the ongoing treatment evidence, not so much for the expertise of the particular occupational therapist that you saw your client a year ago, but it's a great source of a narrative, a third-party narrative of the problems your client went through for years and years. You need to approach it as if you're writing your trial. That's, I don't know a better way to say it, but that's what you're doing. You're setting out, this is who my person is, this is their life, this was their life, here's what they look like, this is their life now. Make sure the reports are as new as you can make them. Sometimes they just simply can't be. There's not much we can do about that. You also need to understand who the people are that you're going to be arguing to, whether orally or in writing. I understand the bios are available. Find out who your adjudicator is. I know that whenever I'm in court, I want to find out who the panel is, because I don't think it makes any real difference that I know what judge in the Court of Appeal I'm arguing in front of, but it gives me some confidence and something to think about, and I've been before this judge before, and you might learn something about how they've decided. And then when you know their name, read the decisions they've written. Maybe they don't have anything to do with your issue, but they certainly might have something to do with how the person writes, how they perceive certain evidence. You can never go wrong in doing more work. You'll never have a problem with that. Now, as far as procedural stuff, I've included this. I don't want to spend too much time on it, but there's a lot of timelines and a lot of things you have to make sure you do correctly. Put together, and it's in my PowerPoint here. This is the one we use at our office. A checklist. So your staff knows when things have to be done, when you know when things have to be done, because you don't want to be doing this at the last minute. So I'll just wind up now. This is new for a lot of people. Well, it's exciting to learn something new. I always enjoy that. I wish they had not given us or taken away what has been a right since 1867 to go to court and have disputes between two private parties adjudicated by a judge and a jury. Thank you very much.
Thanks very much, Brian. One of the things that Brian said was written advocacy in the LAT process is very important. And that also goes for the reports of health professionals. A word, a phrase, a line, or a sentence can change the complexion of the issue. So I know here for the three lawyers that are on this panel, if you have any doubt about reports, we're happy to take drafts and review them with you. And you might say, well, is that permissible or is that allowed? That is preferred. That is good lawyering. That is being a good health professional, is making sure that your reports address the issues and that you know the language. Brian said in his talk there's been 100+ cases that have come out of the LAT in the last almost year. So with that, we're going to hear from Steve on some of the more important LAT decisions since the LAT process has started.
Thank you, John. Yes, there's been about 100 or so cases that have come out of the LAT to date, and I'm guessing there's a pretty good chance that you have not heard of any of them. And I think there may be two reasons for that. One is in the cases themselves, they don't actually use the applicant's names. So in some ways, it's hard to identify them other than by a case number and by an insurance company. The second is that the LAT really has not yet touched on most of the hot button issues that a lot of us care about and spend a lot of time thinking about. There are no decisions, as far as I'm aware, regarding the GOSI scale. There are, in fact, no decisions regarding any of the new catastrophic impairment tests at this point in time. There is only one catastrophic decision that has been rendered so far, and that was on a GCS issue, which really is nothing new and nothing different than what Fiscal would have dealt with in the past. Where I think we do have some clarity, and Benson alluded to this earlier, is on the issue of costs, which is obviously very important to the applicants and the lawyers that are bringing cases. And this was one of the concerns with the new tribunal was, which has come to fruition, is a concern regarding the availability or lack of availability of costs at the tribunal. And the rule requires, and Benson touched on this earlier, the rule regarding costs requires that in order to obtain costs, a party must show that another party in the proceeding has acted unreasonably, frivolously, vexatiously, or in bad faith. And if you have that belief, you can make a submission or a request to the tribunal for costs. And what the cases have said that have dealt with the cost issue is that the proceeding is defined as the tribunal process from the start of an appeal to the time that it's finally resolved. So an applicant, even if successful, cannot make submissions on costs regarding the insurer's conduct that preceded the filing of the application itself. And what you're left with is trying to prove effectively bad faith in the context of the LAT proceeding from the filing of the application. And that has proven to be very, very limited to date. There's one decision in which costs were awarded, and it's a recent decision, BF versus Wawanisa, and it involved an insurer breaching two case conference orders regarding the production of certain documents. The insurer, through its counsel, didn't make any attempt to secure the documents that had been ordered at a case conference, and the applicant's counsel made submissions in respect of costs. The adjudicator in that case stated that the delay in proceedings before an administrative tribunals, which is what this failure to produce documents caused, can undercut their very rationale. the effective and efficient resolution of disputes in a manner that ensures access to justice for all parties. The tribunal's rules and orders must be respected and followed promptly and responsively. So in light of the breach of the tribunal's order itself regarding the production of documents, the adjudicator said this was an appropriate case for the award of costs, and went on to say that the quantum should be high enough to discourage conduct from occurring again. Unfortunately, when it came to actually deciding on an amount of money, the adjudicator awarded $250. And you can imagine that firstly, you can imagine that that sum of money is not going to discourage any insurance company from doing anything. And secondly, the cost of preparing cost submissions and arguing about the issue of costs itself, no doubt greatly exceeded that sum of money. So from my perspective, costs are basically not available at the LAT. This will affect the types of cases that and the stage at which lawyers will be willing to proceed with cases at the LAT. It will have an impact on some lawyers may make the decision that certain cases aren't appropriate for LAT, especially where there is a tort claim and available policy limits are sufficient. Because in that circumstance, one raises the question: well, what's the purpose of proceeding in a system where there's no costs available when you can go through the tort litigation process where there are costs available? Now there is a little silver lining, and it does actually come out of a tort divisional court decision in Carr versus Motti, where the plaintiff sought costs associated with a successful LAT dispute. In the context of cost submissions following a successful jury trial. And in that case, the divisional court upheld the trial judge's decision, which awarded costs to the applicant for the LAT dispute, finding that where there is a benefit to the tort defendant gained through the LAT process, those costs may be recoverable by the plaintiff against the defendant in the tort action. So that is good news. And that will help our clients who potentially have tort cases. But there will be a gap for those that don't have tort cases, for those AB-only cases. And there's a question as to who's going to pay for reports and expert testimony in the LAT system where costs aren't recoverable. And this is something you should most certainly be aware of, especially in those AB-only cases, because it may impact the types of claims and the manner in which lawyers are willing to litigate those LAT disputes. Following up on sort of the decision where costs were ordered for breach of the adjudicator's order regarding production of documents, what I do find that emanates through a lot of the cases is where the LAT adjudicators get mad and get angry and do maybe impulsive things, is where their orders are breached and not followed, and they seem to get angry, especially with lawyers who aren't following their orders, like in the cost decision I referred to earlier. One example of that is a case called JM versus Wawanisa, and in that case, the adjudicator was dealing with various prescription costs, transportation costs, an ambulance fee, all sort of common expenses that were submitted using an OCF 6. And the adjudicator in that case, believe it or not, dismissed the claim for these out-of-pocket expenses because the applicant's written submissions exceeded 10 double-spaced pages, as was ordered at the case conference. I mean, that is rather unbelievable. The adjudicator said that the applicant is represented by counsel. The tribunal expects that counsel will obey its orders. If a party wishes to vary an order, they must raise it with the tribunal ahead of time, and the applicant did not do this. So the lesson there is to follow those case conference orders and follow them to the T, because there will be consequences if we don't for lawyers, and especially in this case that involved submission of invoices. The adjudicator went on to sort of, maybe recognizing that wasn't the best rationale for denying these costs, went on to actually consider the costs individually, still went on to deny them because there wasn't enough support for each of the costs and for each of the invoices submitted, and reiterating the point that the onus is on the applicant to prove entitlement to payment. And in that case, there simply was not enough documentation to support these expenses. Now, one of them was a $45 ambulance receipt, and we all know that That's the cost for an ambulance, and that's a common receipt that's submitted. And it's surprising to me that the adjudicator wouldn't have given the applicant more of an opportunity. But the lesson there is that, and it comes back to Brian's point, is that even for something as small as an ambulance call invoice, you need to have the support, you need to have the documentation, whether you're going to the case conference or to the hearing itself. Another case, again, that speaks to the LAT process, as many of these do, is a case called AB versus Aviva. This was a decision where the applicant was seeking an adjournment of an in-person hearing on the basis that its experts were not available for the hearing, and the adjournment was sought a couple of weeks before the hearing. The adjudicator did not grant it. The adjudicator said that it was not necessary for the expert to testify. There was nothing to be gained beyond what was in their written report, and that's despite the fact that an oral hearing was permitted and that expert evidence was allowed. The adjournment wasn't allowed. So I think from the perspective of the rehab providers, if you know you have a client who's proceeding to a LAT hearing and you know that your evidence is going to be important, you'll want to make sure that the lawyers know your availability, because there will not be a lot of flexibility, and you may only get one chance to testify in person to support your client. A final case I want to talk about briefly is a case called GP versus Kumis Insurance. This case dealt with catastrophic impairment assessments that were requested by the insurer. So while we don't have any great CAT decisions to speak about, we do have one case that deals with the IE requests that were made in response to a catastrophic application. In that case, the applicant had applied for a catastrophic designation based on a whole person impairment rating, which exceeded the 55% threshold. The applicant was relying upon a report by a psychiatrist and a second report by a family physician who prepared the executive summary regarding the whole person impairment rating. The insurer sought to do 5 assessments in response. It later reduced their request to 4. They were seeking 2 occupational therapy assessments. They were seeking a physiatry assessment. They were seeking a psychiatry assessment. And there was a dispute about the reasonableness of the physiatry assessment, which the applicant's counsel refused to allow the applicant to attend. And the reason for that was counsel felt that it did not have a physiatry assessment, and it didn't think that the insurer should be allowed to have one in that circumstance and to have 4 assessments, which doubled the number of assessments that it had. And the adjudicator agreed in that case, despite the fact that its expert doctors had testified that physiatrists are so great at doing these whole person impairment evaluations. The adjudicator found, firstly, that there's no ownership of WPI ratings by physiatrists, and that the test for an IE isn't what's optimal, which is what the insurer was seeking, but what's reasonable and necessary. And the adjudicator found that allowing that 4th or 5th assessment would really just lead to an escalation of the proceeding. It would cause delay. It would require the applicant to respond with its own physiatry assessment. The adjudicator said that in arranging IEs, the insurer should not be rounding up the usual suspects, which is rather harsh language. And the adjudicator noted that insurers should be particularly cautious when seeking multiple insurer examinations, as that will not usually be the most appropriate and least intrusive means of assessing impairments. So I think this is an important case for lawyers and for rehab professionals, especially in cases where lawyers aren't involved. I think there will be an opportunity at the LAT to really look closely at the IE assessments that are being requested. I think the LAT in the context of managing cases efficiently and proportionally is going to have sympathy to applicants where they are being bombarded with IE requests, and we should not simply be sending our client off to the 5 or 6 IEs that have been requested without really giving some careful consideration to what is being requested and why it's being requested and whether it could lead to an escalation of the dispute. So those are my comments on the recent cases. I think we'll see a lot of more interesting cases in the next year or so, especially on the catastrophic issue.
Thank you very much, Steve. Steve, I'm gonna start the questioning with you. So you've got an issue in dispute, and let's say it's a treatment plan. You've got a tort case running along with your accident benefit issues. You talked about being bombarded potentially with insurer examinations. Is there a way you see in having your client get the treatment he or she needs, avoiding the insurer examinations, and moving forward? And I'm thinking of along the lines of protected accounts or something along those lines. What are the tactical and strategic considerations you give to a situation like that?
Well, I think the first thing you're going to want to do in that situation is, I can talk about protected accounts, but first thing you want to do is, as the lawyer, or as the rehab professional, is really get on the phone and try and persuade the adjuster why the treatment makes sense, and try and persuade them why it's in their interest to avoid, a LAT application, which will require them retaining counsel and all sorts of costs, and work that angle as far as you can. We all know that adjusters have supervisors and superiors, and decisions can change with the proper rationale in place. Protected accounts are also a possibility, especially where there is a tort claim. And the thing about protected accounts is I always encourage the rehab providers to explain what that entails, what it means, to make sure that the lawyer has a direction on the file regarding the protected account so that it doesn't get lost later on. And yeah, I think that's a solution, but it shouldn't be the first solution.
Okay, thank you. Benson, here's a question I'm going to ask you, and this is from a health professional who had attended at several ARBS arbitrations under the old system as an expert witness. And the question is, what differences, if any, can this person expect attending at a LAT hearing as an expert witness?
I never appeared as an expert witness under the old regime, so I can't really speak to the differences generically. What I'd say is that one of the features of the LAT process is, as much as possible, is to avoid the unnecessary litigation on things, and to avoid redundant and duplicative testimony and cross-examination on things that aren't centrally at issue. We're not trying to replicate a civil trial with the same breadth of latitude in terms of cross-examining. We'll try and focus it on the issues that are central to the disposition of the case. And I think as Stephen was saying, that in summarizing the last case he was speaking about, that there is, I think, going to be some frustration with litigants who are looking to complicate a process which is complicated enough at its core, and to try and create process and procedures that are simple in order to better inquire into a complex issue and ensure that the evidence speaks to what's going on. I can say that I mean, it was interesting to hear the summary of cases, and interesting to hear Brian's account of the experience of the LAT. And one of the things that I've been struck with the first series of cases that have come through is how many cases have come through where they're just the evidence isn't there. There's a lot of cases where counsel's submissions have sought to stand in for evidence. Now, I think counsel submissions are really important, and I took to heart, Brian's comments that, as a lawyer, you want to be able to frame the case very much, and that's your value add as counsel. And you'll see us moving away from written hearings unless there's an issue that we think is really clearly defined by it, because frankly we didn't find they were working as well as we had hoped. We'll move towards a more oral hearing and more hybrid approach to try and, where there are issues, where there are legal issues perhaps that are best argued in writing, we'll focus on that. But we recognize that some of the written hearings, they just weren't driving the resolutions that we thought were helpful. And one of the things we were dealing with is that we didn't feel we were getting the evidence out. And I think that's the core of making the new system work for you, is to get your evidence out in a way that's really clear, and that it's not simply submissions or assertions by counsel. It's not simply argument. And I think that if you're an expert witness in that context, you have to be thinking that to the extent that you're providing expert testimony on something, and you can, as a professional, speak to that, the tribunal is going to be really interested in what you have to say, because we're very much interested in getting to the evidence at the core, and requiring the parties to prove their cases and to prove their assertions.
Thank you. Brian, this next question is going to be directed to you. Benson just said on a lot of these cases, the evidence just was not there, and the injured individual had obviously not met the onus of proof on him or her. You commented on the experience of the adjudicators and indicated so far that your experience had been very positive. With adjudicators that haven't had a lot of experience, and I don't know what the situation is going to be with following precedents, are you going to change the way you go through a LAT process in terms of what you want from health professionals and reports under the new dispute resolution system?
I think it might be too early to know if changes are required. I'm still going to prepare every case, every issue, as if I'm trying it in a superior court. Because that's the way I've been taught to do it, and have been doing it for 20 years, and it seems to work pretty well. Now, we may have to adapt and change things that would have been done orally. They might have to be done in writing. I'm very happy to hear that maybe we're going towards a little more in oral hearings and actually meeting the people involved. I think that's a positive step. But whether or not you need anything different in the reports, for example, if most medical reports are going to be filed, perhaps more things need to be covered off in the report, because you're not going to be able to have somebody expand on an idea. I mean, you have a doctor come testify now, they can expand on the ideas in the report without getting too much into the nitty-gritty of the details behind. Now, that might no longer be possible, so we're just going to have to wait and see some of the decisions, see what the adjudicators want to hear and don't want to hear, and we're going to have to adapt to it.
Okay, thank you for that. And Brenda, this next one is for you. So what is a situational assessment, and how are situational assessments going to play into and factor into the new system?
So situational assessments, John, have been used by many of us for a number of years. Basically, a situational assessment takes your client into circumstances that simulate real life types of situations. So for example, if you have a client who was a teacher, for example, prior to the accident, and when you're doing a situational assessment with her in order to determine whether or not she is able to do elements of her job as best as we can in an artificial environment, of course, we try to set up the assessment such that it simulates as much as her previous roles as a teacher as best as we can. So like I said, we've been doing those for a long, long time, and I think that they are very important under the new legislation so that we can include those real life examples in our reports. So for example, when we are assessing under the spheres, as in the 4 spheres of function in the AMA Guides Chapter 14 that I mentioned, activities of daily living, social functioning, concentration, persistence, and pace, and adaptation, typically, for me, I will do an assessment that lasts a couple of days. Sometimes people will do this assessment in one day. Sometimes people do situational assessments over 2 or 3 days, or even a longer period of time. But personally, I like doing them over a 2-day period, whereas the first day of the assessment, you meet with the client in their homes and assess them and see them interacting in their homes, in the activities that they were doing and responsible for prior to the accident. And then the second day of my assessment, I try to take them into the community so that we can see the people performing real-life activities that they would have been responsible for prior to the accident, such as driving or shopping or using the bus systems or passing through and walking through traffic lights if, for example, pedestrian anxiety is an issue for them. So to sum it up, it's taking a person's real life circumstances prior to the accident and trying to get the results of that in an assessment as best as you can.
Okay, I'm going to ask a follow-up question. With the Glasgow Outcome Scale Extended, that is the one of the new definitions of catastrophic impairment. There's 8 questions in the GOSI, the answer to one of which can determine whether a person is considered catastrophic impaired or not. And there's 5 categories of function that they look at in those 8 questions. 1 is independence in the home. 2 is independence outside the home. 3 is work, and I'll include work and school. Is that fair? Work and school. Mm-hmm. The 4th is social and leisure activities. And the last category is family and friendships. Can you isolate situational assessments to one of those 5 categories? Like, what I mean by that is they might be doing well in 1 or 2 or 3 of the categories, but it's important to get the benefits, to get the person categorized as catastrophic impairment. Can a situational assessment concentrate in just one of the 5 categories?
I think certainly it can. One of the guidelines that the Wilson, Pettigrew, and Teasdale article does point out is that we have to complete the full assessment, even if the clients may qualify, for example, as catastrophic on an earlier question. So we do have to, according to the SABS, complete the full assessments. But having said that, if you know that your client is independent in the home in question number 2, for example, but they're exhibiting a lot more difficulties in terms of shopping or budgeting or managing their community or with work, then our situational assessments will focus on large part in terms of trying to draw out their level of difficulties in those real life examples if that's the case.
Okay. I'm going to put this next question to anybody who wants to answer it. So under the one of the definitions of CAT involves a certain score on the Glasgow Outcome Scale Extended, but it's also this, it includes this. A person who suffers a traumatic brain injury and the injury shows positive findings on a CAT scan or an MRI. Now here's the words that I'm going to ask about. Or other medically recognized brain diagnostic technology. Some would argue that neuropsychological testing is the most sensitive medically recognized brain diagnostic technology there is. Steve, why don't I start with you? Do you think neuropsych testing falls within the definition?
I'd like to hope so. I don't know. I mean, I don't know. I'm dealing with this particular issue right now. We don't have any case law on that. If you're going to interpret the language generously to the applicant, that's how it is to be interpreted, then possibly. I imagine that is an argument that will be made and will be heard at the LAT in the near-term future.
Brian, what are your thoughts?
I don't know if I want to answer that on a recording because I don't want it used against me if I ever have to argue this. But I don't see how testing is technology, especially when used within that context. That's unfortunate, but that's how I think it's going to end up, but I don't know.
Benson, I say to people, judges hate laws that take away rights from people. So we've got a wide array of adjudicators, you know, some with not a lot of experience in insurance-related matters. Do you have any thoughts on how this might be interpreted? And keeping in mind, you can have some very seriously brain-injured, impaired individuals coming to a LAT hearing who desperately need the added benefits that they'll get from being considered catastrophically impaired.
Yeah, so, you know, one of the conversations that's been taking place inside the administrative law world and within SLASTO and the LAT is, you know, what does we have a regime that allows for the relaxed standards for the admission of evidence, and admin law is based on that premise that you don't have to meet the common law requirements to get evidence before a tribunal. It has to be relevant and not repetitive and not privileged in some sense. So for me, looking at this issue, I think that it's a question of how do you balance the desire to not create, again, unnecessary complexity, but at the same time to ensure that the adjudicators are considering all relevant evidence. And if I were counsel on one of these cases, and I was trying to get evidence in that and to try and meet that requirement, I'd look at the notion of relaxed rules of evidence. I looked at some of the cases that deal with trying to work new or novel scientific evidence into administrative tribunals, because there is a small body of case law that approach it differently. The balance is that generally tribunals will let evidence in, but they adjust according to weight. So unlike the situation where you've got in the courts, that initial threshold of admission, it can be much harder, but once it's in, it tends to sort of it tends to be having met that threshold, more determinative. So I think that somewhere in that balance is probably where the conversation will take place. At the end of the day, the adjudicators are concerned about ensuring that they're casting the net wide enough to capture relevant evidence and not getting tied up into unnecessary legal/technical arguments about it, and they can consider that element with respect to the question of weight. So like everything, and again, I think Brian's approach to how to deal with cases at LAT is deal with them as good lawyers deal with litigation in all contexts, and prepare your evidence, and hopefully you're not going to be reliant on one piece, and you're putting a whole picture together and telling a whole story. And the adjudicators will feel more comfortable, I think, drawing on evidence that may be harder to get in a superior court if you've told that whole story and you've created a safeguard for them to begin to reach out and draw their evidence.
Thank you. Here's another question, Brian, directed to you. You said, Brian, one of the statistics are insurers are winning on the MIG, and the question is this: is it that when a MIG is originally submitted, the patient is rarely taken out? Is that?
Yeah, that's I mean, I don't have the exact numbers, but the insurer appears to be winning on that particular issue. I can imagine why, because the MIG definition in and of itself is very expansive. I mean, almost anything short of a fracture or a provable neurological injury because of organic damage could theoretically be in the MIG. I mean, you could have a very serious shoulder separation with tears to the tendons and still technically be in the MIG. I mean, most insurers, I don't think, are taking that view of the MIG. So when the evidence is just in front of them in terms of the definition and what it says on the paper, that might be a hard one unless you can get the functional impairments in there as well, and the issues with respect to having any premorbid condition that would inhibit. It's just a much harder thing to prove in some circumstances if you're dealing with it in writing. So I think that might be the reason.
Okay, thank you for that. Here's another question, and this I've had some experience with this too. We and I'm going to direct this to you, Steve. And it's basically this: how much is enough evidence at a lat hearing? And my personal experience is very recent. A client of ours was denied an IRB of not quite $90 a week, and the test essentially is a complete inability to work, having regard to the person's education, training, and experience. So there was $90 at stake. The onus of proof is on us. It was an orthopedic injury, involved multiple fractures. We went out and got a report from an orthopedic surgeon. Cost us over $4,500, which in the circumstances was a fair report. The reason we did it, because there's also an LTD carrier, and we thought if they terminated benefits, the 90 could go up to 400. So we felt that was justified and did it, and actually the case resolved at a case conference. But how much, keeping in mind the onus is on you and your client, Steve, how much is enough, and how much is too much, and how much is too little?
Well, I think that will entirely depend on what the issue is, and it will come down to a proportionality assessment to a certain degree. If you're talking about a treatment plan for physiotherapy or psychology, then I probably wouldn't go further than the person who submitted the plan, and a family doctor note is always helpful. If you're talking about issues like income replacement benefit and non-earner benefit, the types of claims that are ongoing and could continue for life potentially in the case of income replacement benefit, then that's a significant claim, and I think you'd want to marshal as much evidence as possible from medical professionals, lay people, family, friends. I would be concerned about losing on an income replacement benefit and having a tort claim ongoing at the same time, or an LTD claim, or a CPP claim, and having that some other insurer rely upon a LAT decision that was predicated on very little evidence, perhaps not even in-person evidence, and that those types of claims that are really going to be at the core of your tort claims or other issues, I think you should marshal a lot of evidence. It's impossible to say what the precise amount is. It depends on the case, it depends on the claimant, it depends on the injuries. But if you're going to go to the LAT, I think you need to be prepared to do what's going to be necessary to win, and that's going to, for certain, mean incurring a significant amount of disbursement, and it will be up to the lawyer and the applicant to figure out how that will be recouped. But I think you need to be, if you're going there, you need to be prepared to spend that money and to make sure you have the medical evidence and the layperson evidence to support your claim.
Benson, let me ask you this: are there going to be restrictions on what lawyers can do in representing their clients in terms of what is too much? And some people would have a saying, certainly not me, but if they come at me with an AK-47, I want to go back at them with a Sherman tank. So are you going to say, Brian or Steve or John, we can only give you 2 days for this, and we can only hear X number of witnesses, and we don't want to hear this or that? Like, are you gonna try and restrict the hearings?
Every case is different and every adjudicator is different. So that's my sort of, weaselly intro to that. But yes, our model, and again, this is a common practice in our tribunals and other tribunals, is we will set time limits and we set procedural restrictions on matters because we're not trying to duplicate what a court does. We're not creating a platform that's the same. We're focused very much on trying to, as I say, narrow the issues and get into an inquiry as to what the evidence is demonstrating. And I don't, like every, lawyers and cases have a great capacity to find ways to sometimes get focused on the issues larger than the conflict at the core of the case. But we don't have a lot of tolerance for the AK-47 Sherman tank approach, and I don't think that lawyers who practice in that way are going to find that it pays to raise the emotional or sort of conflict stakes of a case at the expense of marshalling your evidence and making submissions in the best traditions of the bar.
Okay, let me ask you another question. Where do LAT hearings take place, and are there circumstances when you would allow someone to give evidence by audio-video conferencing?
Yeah, so the hearings will take place. We've got there are new hearing rooms being built at 25 Grosvenor, where the LAT has just moved. They won't be online for a while. So we've got hearing rooms that are at this point sort of scattered over the downtown core. We will also accommodate hearings outside of Toronto as required. So it's a bit of a, we negotiate the space as we go in some cases, frankly. But that should change, and most Toronto-based hearings should be at 25 Grosvenor. We don't have AV capacity yet. It's something we're working towards. And until will be one of the features of the new rooms at 25 Grosvenor, is that we hope to have better AV capacity to allow for the benefits of technology to address some of the issues that have been raised.
Okay, thank you for that. Here's a question that just came in, and Brenda, this is going to direct us your way. If a patient is disabled from his usual work, is he or she considered CAT according to the GOSI?
So this looks at GOSI question number 5, and at the 1-year mark, if the client is not working, then potentially they could qualify for catastrophic. The GOSI tool says specifically, if they were working before, then their current capacity for work should be at the same level. So if, for example, if the client is working in a non-competitive job, so that maybe their uncle owns the store that they're working in, and the situation has been structured for success such that the client is able to function in that environment successfully. That would not be a competitive type of employment. So in my opinion, the client would qualify for catastrophic with that question. So I think it depends on the circumstance, and even though the GOSI is a relatively simple assessment tool, being that there are 8 yes or no types of questions, I think that brings forth the importance of the neuropsych assessment in some situations and the occupational therapy situational assessments to delve into the client's specific circumstance and to explain your arguments in a narrative format that will support your argument if that's the case.
We have less than 2 minutes left. Brenda, I'm going to ask you another question. So we have a hearing coming up. There's a CAD issue in dispute. What can we lawyers do to make your life easier, and what common mistakes or errors do we make?
In terms of your asking us to attend?
Just getting ready for the hearing. Yes, please.
Yeah, I think, I mean, personally, I've been doing this for 18 years, and I've been called maybe 100 or 150 times and never really had to go. I kind of want to go to get that notch in my belt, but again, I've never had to go. But from what my experience is in terms of being called by various parties is that some lawyers will adequately prepare you for that potential arbitration or court appearance, and I think that's really, really important to be able to know what types of questions you might be asked in a lot or a court circumstance, particularly if you haven't been there before. And often, I think that's not the case, John, unfortunately, that many rehab people are called and not prepared appropriately. And I think that puts the rehab person at a disadvantage and the lawyer at a disadvantage, and ultimately the client at a disadvantage as well.
Thank you very much. That is all the time we have. We have a few more questions here, which, as we say, we'll answer by email. The PowerPoints are available to you if you go to the website. I want to thank the panelists very much for attending today, and I want to thank those who did sign on for the webinar also for doing so. We hope that it's proved helpful to you going forward. Thanks.